Thank you. Minister, this week the Peel Regional Police released the results of Project Odyssey, an investigation that lasted 7 months, leading to 26 arrests, 322 charges, and the issuance of 10 additional arrest warrants for auto theft. And among those arrested, 14 out of the 26 were already out on bail for auto theft charges, and 8 of those, even though that was just this week, have already been released. Peel Police Chief expressed exasperation, stating, quote, "We see repeated individuals continue to victimize our community," unquote. So after 9 years of the Trudeau government's lax criminal laws, auto thefts in Canada have increased 34%, with an increase of 300% in Toronto, 100% in Montreal, 100% in Ottawa-Gatineau region, 120% in New Brunswick, 122% in Ontario, and 59% in Quebec. Minister, wouldn't you concede that the Liberal government's actions aggravated this awful situation with the measures that you introduced in your Bill C-75? Bill C-75's restraint principle stipulated that any decision on an accused's release should aim to release them at the earliest reasonable opportunity with the least onerous conditions possible.
So with all due respect, Senator Batters, I reject pretty much everything you just said. So first of all, the reason why the Peel Police were able to effectuate hundreds of arrests and lay hundreds of charges is in part due to investments we made in guns and gangs, which your party frankly voted against. That's $121 million. That's the first point. The second point is with respect to individual decisions on bail. They are pursuant to the parameters that are outlined in the criminal code. You will know, because you looked at this bill at this very committee, that under Bill C-48, we changed the bail reform provisions, which included ensuring that there would be a reverse onus on bail for anyone who commits a crime that is a serious, violent, repeat offender. So right now, if you use a gun in a crime, or if you commit a gun theft that is violent using a weapon, you're subject to a reverse onus. That makes it harder to get bail. If an individual bail decision is rendered by a justice of the peace, it's not rendered by me, as you're fully aware. An individual decision by a justice of the peace in Ontario can be reviewed on a bail review decision. So I'd ask you to put some of those questions to the local crowns. And lastly, with respect to Bill C-75, as a lawyer, I would urge you to reflect on your own training, or perhaps the training of Senator Dauphin as a previous judge. But when you codify in a bill like C-75, Supreme Court jurisprudence like Antic, all you're doing is reflecting the state of the current law, which is what C-75 did. And your party insisted on voting against that bill, notwithstanding the fact that it actually elevated the penalties for summary conviction offenses for automobile theft. So I actually question the actual integrity in terms of your commitment to auto theft in your caucus, at least.
Well, thanks for the lawyer's explain there. Minister, you mentioned C-48 when you were speaking about that as a response to the concerns that I raised about the bail system. But C-48, unlike how you phrased it right there, it was actually a very minimal response to this, despite what the premiers asked for, and it was limited to reversing the burden of proof for only certain very specified offences that had multiple conditions attached to that and situations. So why haven't you proposed since then a much more comprehensive bill that actually reflected those concerns and addressed concerns about offenders about auto thefts? And also, why in your government's Bill C-5, why did you allow increased use of conditional sentences, house arrest, for auto theft?
So again, a few bits of clarification that really need to be put into the record here. So what Bill C-5 did is target things like mandatory minimum penalties that resulted in the overrepresentation of Black and Indigenous persons in this country, in our penal system and in our court system. If that's not a priority for you and your caucus, so be it. Secondly, with respect to what we did in regard to the issues in C-48, is we created a reverse onus for people that committed crimes using serious, violent, repeat offenses. In particular, we enhanced the provisions that deal with usage of firearms. So for your edification, what I would underscore for you is that if you're involved in unlawful possession of a loaded or easily loaded, prohibited or restricted firearm, such as one that might be used in a carjacking in daylight right now in Toronto or in your province of Saskatchewan, that triggers a reverse onus on bail. What we will not do is embark upon some of the things that have been cavalierly posited by the leader of your caucus, which is basically overturn the presumption of bail, which is entrenched in Section 11E of the Charter, by using the notwithstanding clause, something that's never been done by a federal government or someone who purports to assume the mantle of leadership of federal government. On our side of the aisle, we actually stand by the Charter, including all of the Charter rights, which includes the right to reasonable bail under Section 11E.